Welcome. Hi, everyone. Welcome to part 2 of the webinar, Illegal Occupation, Genocide and Business, Reflections on the Case of Palestine. Before we begin, here are some important remarks. This is a two-part series. And part 1 is available at the Transnational Institute website. You will see the link on the chat. If you haven't watched it, please do. It addresses some very important issues that we're not going to be talking about today, such as the responsibility of universities. The chat will also be used to share some further information that the panelists have invited you to take a look. So thank you, Jess, for posting things in the chat for us. We have also reserved some good time for our Q&A, and you can send your questions through the Q&A chat. There's a specific button down the Zoom bar, and well, that's the one. The Q&A session, however, will not be recorded, so just for you to be aware of that. My name is Juliana. I am from the Transnational Institute. I co-facilitate the global campaign to reclaim people's sovereignty, dismantle corporate power, and stop impunity. And they're both co-organizers of this webinar series, together with Al-Haq, SOMO, ETO Consortium, Wageningen's University Center of Excellence on Corporate Sustainability and Human Rights Law, the Essex Business and Human Rights Project, the University of Antwerp, and its Antwerp Law and Development Research Group. Thank you very much for making this possible. As of our panelists, today we'll be talking about the UN Special Rapporteur Francesca Albanese's latest report, From Economy of Occupation to Economy of Genocide, which shows that corporations are not bystanders, but truly enablers of the genocide, of the Zionist occupation, what is happening in Palestine now. They are often also direct beneficiaries of the genocide. In dialogue with Albanese's report to help us understand how to turn this story of complicity and impunity into a future of accountability, our panel today will count on with the inputs from Andressa Soares from the Global Campaign, coordinator of the legal team, and also coordinating the BDS National Committee campaign for Latin America and the Caribbean. We have Dr. Chiara Macchi, assistant professor of law at Wageningen's University, Dr. Irene Pietropaoli, senior fellow in business and human rights at the British Institute for International and Comparative Law, Dr. Michelle Staggs Kelsall, senior lecturer in international law at SOAS, and Dr. Mark Taylor, author of War Economies and International Law. And of course, we will also count on our keynote speaker, who we have the true honor to host today, Special Rapporteur Francesca Albanese, who will now open the floor for us.
Hello, everyone, and thank you for organizing this stellar panel. I couldn't imagine a better setting to move forward, because the report that I'm going to briefly present in its key findings in a moment wouldn't be possible without many of the illustrious panelists here who have been enlightening lawyers like me who had until a few years ago a very poor understanding and not enough knowledge to understand what I know today. So without them, without their scholarship, without their engagement, I wouldn't know what I know, but also there are some in particular among you who have been providing support, advice, and I'm really grateful. So after writing 5 reports as a special rapporteur, 2 of which were about genocide, I didn't have much expectations to be able to produce something groundbreaking. And yes, I did. This report unveiling the economy of the occupation is groundbreaking. And in fact, it has led me to be the first UN person to ever be sanctioned by the United States because, as someone says, I've poked the bear in the eye, threatening the global economy that underpins some of the most abominable violations of international law. And the work of Mark Taylor speaks globally to this phenomenon. But let's focus on the report. How it's possible that while Israel was destroying Gaza and the economy of the country, Israel, was resenting it, people were losing their jobs, businesses were closing, Tel Aviv Stock Exchange kept on growing, and it has amassed over $200 billion in over 600 days. It's incredible because there were people profiting from what Israel was doing. But let me go back to the basic. Settler colonialism, which is what Israel is and does in the little that remains of the occupied Palestinian territory, Gaza, the East Jerusalem and the West Bank, taking the land, taking the resources, displacing the native population, the Palestinians. It's not, what I'm saying is not new, has always, settler colonialism has always been underpinned, sustained, accompanied by private actors. What is shocking here, that is still happening in the human rights era, while we have had the flourishing of the international human rights system, norms and mechanisms. Why? Because the private sector, businesses, but not just companies, tend to escape the control, the ruling, the oversight that the international human rights system has set up. Over 57 years, without even looking at what Israel has done in historical Palestine, Israel has been helped and has relied upon the private sector to displace and replace the Palestinians. How? Because in order to displace them, to take the land, to secure the land for the settler, Israel used arms manufacturers from Israel and from outside Israel. It has used the surveillance technology, the confinement tools that were needed to segregate the Palestinians by using construction companies and materials, from the uprooting of olive trees, the destruction of homes, and then the construction of what I've called in another report, the carcerality infrastructure, the gates, the segregated roads, the checkpoints, and so on and so forth. These has been used to displace the Palestinians, and once the Palestinians have been displaced, another pillar made of different components, and this is even more colorful and articulated, of private actors has come into play. Businesses have helped Israel build colonies, water infrastructure, electricity grids, roads, trains, not just to connect the colonies to Israel, while segregating, further fragmenting, incarcerating the Palestinians. And of course, the first pillar was interjecting, because at every attempt of the Palestinians to protest or just to conduct their life, they've been facing with violence, with weapons, and all what it has entailed. Of course, Israel has also set up, as part of the replacement, businesses. There has been the supply chain getting into this. It has produced vegetables, beauty products, pharmaceutical products, and all industry has flourished by exploiting the water stolen to the Palestinians, the other resources, the quarries, the land, the fossil fuel outside Gaza. And by also exploiting the Palestinians, forcing them into a captive economy. And these would have not been possible without the enablers, without a full circuit of actors lending legitimacy. So we are not just talking of businesses per se, but universities continuing to partnering with Israeli universities, but also doing research like the Center for National Research in Italy. I've engaged with them. They say, but we do neutral research. There is nothing neutral in dealing with an unlawful occupation, and everyone should know that. But everything has been normalized of the Israeli occupation, and pension funds and banks and a variety of actors, including charities, have kept continuing this pretense of the Israeli occupation being business as usual, the United Nations as well. Because after 70 years, if you're not part of the solution, you might be part of the problem. And this is something, if we don't look into ourselves today, at the moment, Israel is really starving and genociding the Palestinian population. We are doomed to fail as a humanity. Now, I could have written this report decades ago, also based on the enormous production of civil society actors from the BDS, SOMO, Don't Buy Into the Occupation, Who Profits. This report is not, I mean, what I do is just to put everything together and give it a name, from the economy of the occupation to the economy of genocide, because this is the next thing I wanted to say. Companies, private actors, universities were on notice because civil society for decades has informed them that they were engaging with something illegal. A cement company which exploits and exhausts quarries is not just rendering a service to Israel, is committing or is complicit with the crime of pillage under international humanitarian law. So companies, universities have been put on banks, pension funds, they've been put on notice. They've just been pretending not to understand the standards that apply to the private sector. Because the common justification, and they've been put on notice, all the companies I've mentioned, they say, yeah, but international obligations are for states. And so this is the paradox, how it's possible, even if we lived in a world where there were the standards that exist to bind the let's say the private sector, which, as I said, needs to be understood as a broad concept. But is it possible that a private actor can participate in violations or in actions that are prohibited to member states? And of course not, because there are states, historically companies, and there are people better suited than me to explain that, but there are companies that have, that have been held accountable historically, because while companies have always tried to escape regulations, have even become shapers of international law historically, then after the Holocaust, the post-Holocaust industrialist trials, and after apartheid, there has been an attempt advancement of international law, sort of creating some protective tools for individuals from the rapaciousness of the private sector. And Palestine is putting now everything to test. And my sense is that if we succeed in understanding what we are facing, because this is not just happening to Palestine, it's happening to the rest of the world, and Congo speaks loud to what multinationals do to people's self-determination, if not brought under check. But however, over the past, so the standards are there. And the last thing I wanted to say, over the past 650 days, the reason why the Tel Aviv Stock Exchange that I mentioned in the beginning kept on rising is because people have profited from the genocide of the Palestinians. And of course, the arms manufacturers, first and foremost, Lockheed Martin, Elbit, Leonardo, Italy-owned Leonardo, keeps on providing weapons that are being used to slaughter the Palestinians. This is not acceptable. I keep on saying states, authorities, governments can be complicit, but not the people. And this is why now we need to have this knowledge, because of course there are arm manufacturers, but also others should have disengaged from this. They have heightened their cooperation with Israel, like the big tech and the banking sector. They have helped the Israeli economy, the Israeli state survive while it was facing an unprecedented budget crisis, financial crisis, because of the military expenditure soon after October. And so if Palestine were a crime scene, it would carry the fingerprints of all of us. And this is why it's fundamental that today we know how to understand, face, and resolve this system of entrenched injustice. Thank you.
Thank you, Francesca, for your work, for the inspiring energy and dedication. Our solidarity to you with this persecution you are facing now, and for this presentation that shows us that it's clearly not about a few bad apples, few individual companies with evil CEOs that don't understand the standards, right? It is about a globalized system that puts profit above life every day, and about the legal frameworks meant to hold these corporations accountable. And to understand a little bit more what these frameworks are, Dr. Chiara Macchi's work should help us take this first look. One crucial thing standing out from the report is that many of the corporations named there are publicly endorsing UN guiding principles, for instance. So, Chiara, how can we reconcile these companies' stated commitments with their documented actions? Could you help us understand why the distinction between contributing and direct linkage between business and human rights violations matter for corporate accountability?
Yes, thank you, Juliana, and thank you, Francesca, for your presentation and for your invaluable work. And indeed, first of all, why do we need to talk about the UN Guiding Principles on Business and Human Rights? Because although they are a soft law instrument, they are the most authoritative standard of corporate conduct at the international level, and they have been relied upon to interpret and clarify the obligations of states and corporations by domestic courts, but also by the Inter-American Court of Human Rights. And as you said, they have been widely endorsed by states and corporations. As a matter of fact, indeed, most, I would say, of the corporations cited in the Special Rapporteur's report have endorsed them and publicly claim to follow the guiding principles. You can easily check that yourself. Elbit Systems declared to adhere to the UN guiding principles while supplying weapons and drones used by the IDF in Gaza. BNP Paribas emphasizes its support for the UNGPs while being a top European financier of the weapons industry supply in Israel. Airbnb, Booking.com, Carrefour, Caterpillar. You will hardly find any company in the report that do not publicly claim to respect international business and human rights standards. And yet the facts show a very different picture. Now, under the UNGPs, companies have a responsibility to address their own direct and indirect involvement in human rights abuses, a responsibility that becomes more stringent in context of serious and widespread violations. As concerns direct involvement in human rights abuses, under the UNGPs, companies must avoid causing or contributing to human rights violations. Causation or contribution means that there is a causal link between the company's acts and the violations. This is most likely the position of many companies cited in the report whose activities are directly facilitating the violations suffered by the Palestinians. As an example, quarrying, the German company Heidelberg Materials is cited in the report because it engages in quarrying in the OPT. This activity, carried out without the permission of the occupied government, breaches the law of occupation and constitutes the war crime of pillage. Heidelberg Materials, while publicly claiming to align its business practices to the UNGPs, and international standards is most likely causing the international crime of pillage. This is in stark contrast with its responsibility under the UN Guiding Principles and could also lead to liability. In cases like this one, the UN Guiding Principles require the company to cease causing or contributing to the abuse and remedy the abuse. And this responsibility precedes and is independent from any finding of liability. In the context we are examining, this responsibility will in most cases require cutting ties, divesting, exiting, cutting ties with the Israeli government, the military, ceasing all activities that are facilitating illegal occupation, genocide, and other international crimes and human rights violations. But under the UN Guiding Principles, even more indirect forms of involvement engage the corporation's responsibility. There are hundreds, maybe thousands of companies and investors out there that might not be directly contributing to the abuse, but that are nonetheless directly linked to them. Under the UNGPs, these companies too must take human rights due diligence steps. They must cut ties with abuses they cannot mitigate. One of the most telling examples in this respect is the financial sector, and the report names banks, institutional investors, asset managers that are funding companies like Caterpillar, Palantir, Lockheed Martin, Leonardo, and many others whose products and services might be causing or contributing to the commission of international crimes. In a 2017 note, the Office of the UN High Commissioner for Human Rights warned that some investments can rise to the threshold of financial complicity if adequate steps to mitigate the impacts are not taken. But it also warned that investor responsibility arises even when a direct causal link between the investment and the violation cannot be proven. Example, the Norwegian pension fund. It is a non-controlling minority shareholder, for instance, in Caterpillar, whose equipment was notoriously used to demolish Palestinian homes. Is the Norwegian pension fund off the hook because it only holds 1.2% of Caterpillar's shares and does not control its operations? No. The fund under the UNGPs retains a duty to assess the risk and to conduct human rights due diligence. And then, if its leverage cannot mitigate the abuses perpetrated by the investee company, then it must divest from it. Back in 2006, the Council on Ethics of the Norwegian Pension Fund decided not to divest from Caterpillar, for instance, based on the fact that the equipment it sold to the Israeli army, quote unquote, also had legitimate uses for the buyer. This is not how due diligence works in the case of dual-use equipment. You cannot simply wait and hope that your investment will only contribute to legitimate uses when there is wide evidence to the contrary available. The OHCHR warns that there is a fine line between linkage to and contribution to the abuse. If a company linked to an abuse fails over time to conduct due diligence, then it will eventually move along the continuum and find itself in a position of contribution. And let me conclude with two final points. One, the UN Guiding Principles on Business and Human Rights are explicit in saying that if you as a company fail to cease your involvement in a human rights abuse, you cannot offset this failure by doing positive deeds elsewhere. The Special Rapporteur's report illustrates the case of Airbnb, which, and I quote from the report, briefly delisted illegal colony properties in 2018, but then reversed course under pressure, now donating profits to humanitarian causes. Now, this is not how you conduct human rights due diligence under the UNGPs. You discharge your responsibility under the UNGPs by cutting ties to the violation, not by keeping those ties and then donating to charities. This is a type of offsetting that is not admitted under the UNGPs. My second point, is it possible that in 2025 companies and investors are not aware of their own link to international crimes in occupied Palestine? The answer is no. UN reports already in 2013 and 2018 warned about the serious human rights concerns raised by certain types of activities in the OPT and stated that it is very difficult to imagine a scenario in which a company could engage in listed activities in a way that is consistent with the guiding principles and with international law. And yet, Dr. Albanese's report shows that still in 2025, some of the largest banks and investors keep in their portfolios companies that are obviously involved in those activities or that supply weapons and dual-use equipment to a state that is committing egregious human rights violations and genocide. The question is also, what does this make of those companies, banks, even universities that attract clients, investors, business partners, even students by presenting themselves as human rights compliant, sustainable businesses and institutions while retaining their contribution or link to serious human rights violations, illegal occupation and genocide. This is a form of blue washing that in some cases might even engage liability under consumer protection statutes or under tort law. At a minimum, it shows an incomplete understanding of business responsibility under the UNGPs and the failure to comply with those standards in good faith. Thank you.
Thank you. Thank you very much, Chiara. From your presentation, it does make us wonder, right? If human rights due diligence can be used or reduced to a PR exercise or even justify business as usual. We wonder if Dr. Irene could help us understand what meaningful human rights due diligence could look like in Gaza, considering that even humanitarian aid is being weaponized. What is the concept of heightened human rights due diligence, and what would exiting really means? Dr. Irene.
Good morning. Thank you, Francesca, and thank you for the invitation. I'm honored to be here. Yes, and this is just a follow-up to what Chiara described, the concept of human rights due diligence that was developed by the UN Guiding Principle on Business Human Rights already in 2011, the OECD guidelines, and then in practice and guidance, including by the UN Working Group on Business Human Rights, also clarified that in situation of conflict and high-risk context, companies are expected to conduct heightened human rights due diligence with the aim of prevention, human rights impact, and then mitigate them. So this is an understanding that in every situation of conflict and high-risk context, generally, business can never be neutral. They are going to have an impact on the situation, so business must understand not just the impact on human rights and the environment, that's like the normal, let's say, human rights due diligence, but also the wider impact on the context and on the conflict. So this is the general standards. However, and here I want to make 2 points. First, there are cases where mitigation is not possible. Where leverage that the business are supposed to use is not possible, and where implication directly or indirectly linked with or involved or implicated or cause and anyway is with a gross human rights violation and international crimes is inevitable. In those cases, and this clearly is the case of the illegal occupation of Palestine and the ongoing war and the genocide in Gaza, there is no other way for companies but leave, terminate the business relationship and exit in a responsible way, meaning like understanding the impact that they already have, provide redress and reparation and leave. Companies in those situations are bound by rules of international humanitarian law, and this clearly, as also Chiara mentioned, the situation of involvement has already been notified clearly, even if not earlier, already with the International Criminal Justice Preliminary Order, finding like a plausible risk of genocide. That was January 2024. At that point, third states, home state of international company, were bound by the Genocide Convention to do everything possible to prevent and punish genocide, including regulating the business that are headquarters in their jurisdiction. And then, of course, there have been like a number of UN resolutions, also the ICC arrest warrant. So, and this is my second point, staying as many business that Francesca listed in a report have done, staying and continuing the business relationship with Israel, with Israeli government, with Israeli armed force, means the risk of complicity. And even just benefit from the situation there. So it's not just company that, of course, provide essential goods like arms, weapons, technology, artificial intelligence, financial, but also just company that stay there, risk complicity. It was like the case of South Africa after apartheid in 1997. The Truth and Reconciliation Commission thought that the business sector had been central to the economy that maintained the South Africa state during the apartheid. And of course, there were some sectors that were more involved in the apartheid, of course, the military industry, the financial institution, but most business were just culpable by just the virtue of benefit from operating in that racially structured environment. My other point here also is important to keep in mind that conducting heightened human rights due diligence is not a defense. So even companies that have done that, and arguably companies have not done that, but even if company did, they are not, that doesn't mean that this is a defense. And so they could be held, they risk to be complicity in violation of international human rights law, international humanitarian law, and they risk criminal liability. And I know that Mark is also going to develop on that, but just to mention that, of course, criminal liability for international crime has been attempted, sometimes successfully, a number of times after the end of World War II. And this is possible for both the company executives as individual, as business people, that could even be liable under the ICC, International Criminal Court jurisdiction, but also the corporate entity itself. And that, for example, in domestic jurisdiction that attribute criminal liability to corporations. And that has been, there have been a number of examples in the Netherlands, in France, a number of cases, including the recent well-known example of the case against Lafarge in France for involvement in Syria. And here I conclude. I want to mention that, as it was said before, the reliance on the private sector backed by the US has now also been used in the delivery of humanitarian aid with the Gaza Humanitarian Foundation, that is a segregated startup private organization. Since the beginning of this operation in May, so in about 2 months, more than 1,000 Palestinians have been killed while trying to access those very few, only 4 food delivery points. They were shot by, alleged by Israeli security forces. And this is another organization that risks complicity in violation of international humanitarian law. Keep in mind that corporate complicity implies the corporation may hide and abet the violation perpetrated by others, by government force. And international criminal law suggests that direct complicity requires intentional participation, but not necessarily an intention to do harm. So just the knowledge of a foreseeable harmful effect is enough. And I argue, and I'm going to link now in the chat an opinion that I just published last week with Sarah Razai, one of my colleagues at Bicol, the harmful effect on the starving Palestinian population are foreseeable result of the design and operation of the Gaza Humanitarian Foundation. Thank you.
Thank you, Irene. Thank you also for steering the conversation in direction of more enforceable frameworks instead of just the voluntary ones. And before we move to Mark, I think it would be good to hear from Michelle to understand what would be these obligations. How does the International Court of Justice most recent rulings redefine heightened human rights due diligence? How does the Genocide Convention apply to corporations? Dr. Michelle?
Thank you so much. And yes, absolutely. I think to reiterate both what Chiara and Irene have already said, heightened human rights due diligence in this context is absolutely imperative, and I would argue has now crystallized as a customary international law norm. In other words, there's no way in which companies can now say, we can't engage in due diligence in the situation in the occupied Palestinian territories, precisely because what we are facing here is a situation of the obligation to prevent genocide. Now, to be very clear, my intervention really is reiterating that business obligations to withdraw and to refrain from causing, contributing, or being directly linked to the violations Israeli forces are now committing in the OPT is a direct obligation, both on states and corporations. And this is because Article 1 of the Convention on the Prevention and Punishment of the Crime of Genocide does not require for it to be proven that the genocide has actually occurred. Obviously, that would make no sense at all. It would be nonsensical, as it would be only after the population in question had been completely destroyed that the obligation to prevent would be established. So what we see here in the ongoing jurisprudence coming out from the International Court of Justice is that positive steps must be taken both by states and business enterprises to prevent the daily atrocities committed against the Palestinian people. And if we take as given that the conduct of human rights due diligence is crystallizing now as a customary international law norm, then we can further argue this is a direct obligation on business enterprises as well. Now, upon what grounds am I claiming that it's now an international law norm? Well, I can quote here from Sotomayor's dissent in Jesna v. Arab Bank in the United States Supreme Court, where she says the international law norm against genocide imposes obligations on all actors. Acts of genocide thus violate the norm, irrespective of whether they are committed privately or in concert with the state. Obviously, that's a dissenting opinion from the highest US court, but that is reiterated by the academic commentary coming out about the crystallization of the UNGPs in relation to human rights due diligence and what that then means upon corporations once they've conducted that due diligence, is effectively to do, as both Irene and Chiara have said, to withdraw, to use their leverage in order to prevent further violations. And how do we know this? Well, we know already the OECD guidelines on multinational enterprises endorses the UNGP framework's human rights due diligence process. And we also know that now the EU has passed a directive which will mean that 27 European states are now being regulated in order to ensure this forms part of their domestic legislation. So we are on the cusp of this crystallizing already. And in the case of genocide, the obligation to prevent, therefore, makes it very clear that it's not solely a norm that has to be enforced by states, but also by business enterprises. How have we seen this? In the ICJ over the past 2 years, we have seen an ongoing documentation and citation of the Bosnia v. Serbia case of 2007, in which the court stipulated that states have the responsibility to employ all means reasonably available to them to prevent the genocide. And there is a heightened responsibility for states that have the capacity to influence the state committing the genocide due to the strength of their political ties. The responsibility is to act to prevent genocide on the part of the state, regardless of whether the actions are likely to succeed or not. And all states must act, because it's only through a combined effort of several states acting together that the commission of genocide will be averted or prevented. In Nicaragua against Germany last year, the 2024 decision, this was reiterated by the ICJ, and indeed part of the reason why the ICJ did not issue provisional orders against Germany was because Germany was on the hook under the Arms Trade Treaty in order to ensure that where there is a risk of such acts occurring, that it withdraw trade in arms with Israel in this instance. So all states who are aware, or that should normally have been aware of, a serious risk that acts of genocide are occurring, this is again in Nicaragua v. Germany, the ICJ says should employ all means reasonably available to them to prevent the genocide. Similarly, under the guiding principles, as I've already mentioned, they've been approved of and adopted by other international instruments consistently and referred to by several international law scholars now to be crystallizing in the force as a force of law. So I think we're at a point now, at a moment where it's indisputable that actions must be taken both by business enterprises and by states to ensure that the ongoing violations of international law and acts of genocide are no longer able to be committed by Israel. And I would say politically, to add to this legal context, what we have now is a very strong statement from Emmanuel Macron acknowledging the state of Palestine, the right, therefore, of self-determination of the Palestinian people. And I think what we need to do now is really act upon that, as Francesca has mentioned, all of us together, to shift from this idea of self-defense, which it is clearly no longer at all an issue, if it ever was in relation to Israel, towards self-determination and ensuring that that right is able to be exercised by the Palestinian people, indeed by saving their lives on a daily basis. In his thesis on Feuerbach, just to end, Karl Marx famously stated, "The philosophers have only interpreted the world in various ways. The point, however, is to change it." I would hope that we can all now act to change the situation and do what we can in our power to do so. Thank you.
Thank you, Michelle. Very important quote for us to be reminded of. So if we understand correctly, then we do have tools, right, to hold corporations accountable, at least for international crimes. But we wonder now, how could they be enforced? We pass on now to Mark, because his work has shown how some national courts have occasionally been able to address corporate complicity. So Mark, can you let us know more or less how these mechanisms operate in practice? What are the lessons learned from these cases, and how could they be applied to the companies named in the report?
Sure. First, thanks very much for the invitation from the organizers of this session, and thanks in particular to Special Rapporteur Albanese for her report, which I really would commend to all of those listening to read. It's an excellent overview of the political economy of dispossession or displacement and replacement, as she calls it in the report. And for that reason, it's extremely useful in questions of legal accountability at the national level. And I'm going to come in to explain a little bit why and how. First, I need to make I'm a civil servant, and I'm in a private capacity. So nothing here represents the views of the government of Norway or the agency I work for. That being said, what the report does extremely well, and Francesca mentioned this earlier, is provide a synthesis for an understanding of the ways in which the private sector engages in the political economy of dispossession. And from the perspective of international criminal law, and in particular the implementation of international criminal law through investigations and prosecutions, this is exactly where you want to start an investigation. It's the basis for an analysis-led investigation, which gives you leads and gives you potential accomplices and perpetrators. So that synthesis that has been created here really is, I think, something that prosecutors in different jurisdictions, in particular in national jurisdictions, should be using to investigate companies that fall within their jurisdiction, or to be investigating business individuals that fall within their jurisdictions. It identifies the main value chains and the ways in which those value chains intersect with what the international criminal lawyers would call and investigators would call the crime base. So how, in the 3 or 4 minutes that I have left, can we get to grips with what this crime base, this corporate crime base in Palestine actually looks like? And I'd like to point out sort of 3 main categories that are relevant here. The first, and relevant because they're reflected in existing case law at the national level, international criminal case law or international civil litigation against companies accused of international crimes pursued at the national level. So the first is supply chains, and here we have 2 cases that were both pursued as criminal law cases in the Netherlands. One for the provision of chemical components in the use and production of chemical warfare against Kurds in Iraq. And the second involving the provision of arms and violation of sanctions in the timber trade in case of Liberia. Both of these were cases where the mode of liability was aiding and abetting, and both involved international crimes. And so if you look at the report that Francesca Albanese has produced, it's this kind of supply chain liability that is going to be applied to the weapons producers, those producing dual use, those providing logistics and fuel. And you're going to want to determine from a factual perspective to what extent those companies knowingly participated in the provision of weapons and dual-use components that facilitated those international crimes being committed by Israeli perpetrators against the Palestinians. The second kind or scenario after the supply chain scenario is the foreign direct investment scenario. And here the main prosecution that has occurred involves the Ford Motor Car Company in Argentina during the period of the dictatorships. And what that case really showed was the nature of a strategic relationship between a company and the authorities, in particular, in this case, the security authorities, in the commission of the crime of torture. And there's a case being prosecuted as we speak. It's a trial in Sweden involving the executives of the Lundin oil company for alleged war crimes committed by the government of Sudan 20 years ago. And that case will wrap up next year. And again, I think in that case, you're talking about a fact pattern where that strategic relationship in which an oil company is relying on the state to provide to use its coercion and violence against civilian population to provide a business opportunity, to make it, in a sense, business friendly. The third kind, and here, of course, you're looking at, if you look at the report, you're looking at examples from in Palestine, from the agricultural sector, from the natural resource sector, and so on. The third kind is what I would call illicit exploitation, and that's where commodities or services that are based on international crimes are integrated to our global value chains. And people have mentioned here pillage as a basis for that. In other words, commodities that are exported by companies from Palestine that are based on the crime of pillage, which is basically theft of public or private property in occupied territories. Forced labor is another one. So where goods are produced through forced labor and introduced to global value chains through a kind of laundering process. And laundering is the key word here, because money laundering statutes have been attempted to be used at the national level to get at some of these things. My time is and here the kinds of examples from the Albanese report we're talking about are the platform economies, the retail sector and the logistics sector. My time is running out, so I just want to make a couple of very brief points at the end, which is to say these are not mutually exclusive. And one of the ways that they're not, these three categories of the corporate crime base that I described are not mutually exclusive. And some of the key ways they're not mutually exclusive is that finance runs throughout, and this is something that that Francesca has mentioned in her report. Logistics runs throughout, and dare I say, legal aid, legal services run throughout. But one of the key aspects I want to raise here is that that they portray everything from the sort of most basic kind of aiding and abetting the provision of weapons for the commission of international crimes, all the way over to systemic criminal enterprises. And what we see from other contexts, in particular Russia in occupied Ukraine, and in Syria during the civil war there, is that these three types of activities can actually become sort of full life cycle criminal enterprises. Think, for example, of the sieges of Mariupol, which are then leveraged for sort of Russian reconstruction, where companies are brought in. Similar dynamics in Syrian cities, where sieges were imposed by militias operating alongside Assad forces, militias sponsored by business people. The rubble from those after people were expelled from their neighborhoods or cities, the rubble is then extracted by companies operating for the same people, and the scrap metal from those from that rubble is then exported. And I do think that in the context of Palestine, you have, in particular Gaza, I'm going to stop right now. You have this concept of siege as a criminal enterprise that really does need to be used as the narrative at the level of understanding the criminal enterprise and the way that business is involved in all different phases of it. My apologies for going over time.
No worries. I did say I was going to be somewhat lenient, so thank you anyways. So if we understand it correctly, we do get liability. Michelle, Irene, Chiara has explained that very clearly for corporations. And these cases that Mark has just presented, they show that litigation is also possible. But it feels like it is also very uneven and quite slow. We should need we need to move beyond ad hoc lawsuits towards systemic change, right? What Albanese's report has shown is that this is the modus operandi of corporations. They will make money in times of peace. They will make money over dead children's bodies. So with our final panelist, we're hoping that she can bring in some light into understanding how to standardize and enforce accountability, since this patchwork of voluntary guidelines and national legislation has really failed to prevent complicity of corporations with genocide. So Andressa, could we hear from you, from your experience with BDS and the global campaign? How can we dismantle this architecture of impunity?
Yeah, very big question. But firstly, thank you so much for the invitation. It's 5 a.m. in the morning in Brazil, so I'm really sorry if I'm not making completely sense, but I could not be here and participate in this amazing panel. So as Juliana said, I'm also a lawyer. I come from a scholar background, an academic background, but I've always worked with civil society along processes regarding corporate accountability. And I started working with business and human rights before I moved into working with the BDS National Committee and Palestine, because BDS is a movement that claims for compliance with international law, and that long ago saw this relation between corporations and the violations of the illegal occupation, apartheid system, and now genocide that we see in Palestine. And that's what is amazing about Francesca's report, is that shows us exactly how this is part of a complex system. And this is another chapter of the architecture of impunity that Juliana was saying, that civil society and the global campaign we have been working with since 2013, since it was founded, the campaign. And we have been noticing how especially transnational corporations evade liability whenever they can, and not only because it depends a little bit on court or it depends on the understanding. It's how the system is designed, right? It's how the system is designed and how they are designed structurally to evade liability. So how to deal with that? Of course, the framework we have today, as the other panelists were highlighting, we have some ground and some legal ground to hold companies accountable or liable, and at least to pressure for divestments and sanctions in some situations. However, in reality, what we see is that this framework falls short, and falls really short. So as civil society, we started to think how we could go beyond that and how we could push for more. The UNGPs, there are the common framework we have today as understanding as a consensus. Of course, it's not enough, not only because it's not binding, because this is a very big problem, even though, as it was mentioned today, companies that committed to the UNGP, although we know they are not committed really to the UNGPs, they do not act on it, and they cannot be made liable on it unless we depend on some court understanding that is binding, etc. But the obligations there are not binding. It's a voluntary framework. But this is not the only reason why the UNGPs are not enough. And what we have seen during the years that the UNGPs came out since 2011 is that we noticed that the big violations, or the gross violations, as we say, increased in the global south. And the cases in the same year that the UNGPs were launched, we had Rana Plaza, then we had Chevron in Ecuador. We had a lot of these landmark cases that showed us that it was not enough, and this could not be the only direction. Even Joe Ruggie, when issued the UNGPs, he said, this is a first step, this should not be the ceiling. But what I'm saying that maybe for us it's obvious, you know, but the UNGPs are used as for by companies and by states that protect these companies and TNC's interests by some shield for liability. So this is the first problem. But the other problem I was mentioning is not only because it's not binding, because even if we had binding UNGPs, it wouldn't be enough, because the UNGPs fall short in especially jurisdiction and liability regarding fail to prevent, rather than other obligations far further than due diligence. And why I'm saying that? Because civil society started to push to a parallel process, that is the binding treaty that is being discussed in the UN right now. And we are very committed to it, and not by chance, it's just because we do believe strongly this is the way that we can fill some of the gaps that we have today in pursuing liability. And since the beginning of the process, it's really funny to notice how the discourse changed a little bit in order to stop this process. So because this is a process that poked the bear in the eye, as Francesca said, this is a process that aims to fill some gaps of the architecture of impunity that companies navigate today to act and to profit from. So first of all, we used to hear in the room that this process was not needed because we had the UNGPs. when they could not further use the UNGPs as the shield and say, okay, now it's pretty clear what we have in society, that the UNGPs are not being enough, then they started to try to guide the process into a due diligence process. And who is they? Pretty much the US that tried to diminish the process a lot of times, and the EU, as you was mentioned today, they just issued a directive. Other countries within the EU as well have due diligence norms, and even better than the directive when it came out, civil society in the EU was really disappointed with the result of the due diligence directive because they lost a lot of important points in the process. But we see that they put these things as a dichotomy, like either the binding treaty or the UNGPs, or they try to establish or to guide the binding treaty into falling in within due diligence frameworks. And one thing that we say is they are not, there is no dichotomy, they are complementary. So we should see due diligence norms with their importance, but with their limitations as well. For instance, from the Global South perspective, we are having some problems with the due diligence legislations that already came out, especially in litigation in real life, because when we talk about, for instance, the Germany due diligence legislation, there is no civil liability for not complying with due diligence, and it's even harder to pursue liability for the violation because we have to prove not only the causal link between not acting on due diligence with the violation, but also that the due diligence failed to prevent the violation, which is really hard for victims in the Global South to prove. We don't have access to information, we don't have transparency, so it's a very high standard of proof. Also, with the same thing with the Loi de Devoir de Vigilance in France, we do have some good provisions there, but it's really hard. And now we have the first cases coming out of courts with Total versus Uganda case, etc. We can see how they are pushing into a way of for victims to prove that the fail in the vigilance plan was the one that led to the violation. That said, this is an inherent complication of due diligence. I'm not saying it's not a useful tool or prevention tool, but it's not the only one, and we should not base liability on this tool only, on this prevention tool only. That said, and I'm going to try to be a little faster here, some things that we pursue while we are in the binding treaty process, and that's why it's so fought against it. We need three straight pillars: prevention and prevention obligations for business. So as Francesca said, and all the colleagues said, Michelle, Irene, etc., we already do have some obligations that lie on business now. But they try to avoid it because they say they are not binding. We depend on some court understandings, etc. So the idea is to have a binding regulation stating those obligations clearly, specific to business, but not only this, but other obligations of prevention, including mandatory due diligence, but not limited to it. We can have like FPIC, prior and informed consent. We have a lot of good developments in the Inter-American African Court of Human Rights. We are further...
It's taking a minute.
Okay.
Thank you.
Just 2 minutes and I'm finished. I stopped talking, I promise. Juliana knows that I'm not very good with time. But we have some developments from these regional systems that push even further than the European system with corporate obligations. We have, and we also advocate for joint and several liability and jurisdiction. These pillars, extraterritorial jurisdictions, we need this to hold TNCs accountable. We know they hide behind the corporate veil. Israel. They have deterritorialized structures. They do not fall only under one jurisdiction. So we do need some kind of global standard. And that's what we are pursuing in the Binding Treaty, to be able to hold these companies accountable. And joint and several liability through the value chain. As we say, this is the question of the $100 million. I mean, how we can make companies liable throughout the value chain. And joint and several liability is a way to do that. And so I invite every lawyer here that is watching and people that are engaging the process of holding business accountables, not only, of course, Palestine. I believe we all have the understanding that Palestine is now the light of what is going to be international law from now. So I think it's the case that it's the fireproof for international law. So this is the urgency now, but to understand how it's not only about Palestine, but the whole system of architecture of impunity, colonization, and how it's important to engage in these discussions with the Binding Treaty, especially pressuring global South countries to engage in this discussion, because together they can face race to the bottom and they can face the pressure they have from global North countries. It's funny that sometimes in the room we see some countries. Okay. Some countries and some representative of business pressuring global South countries. So I invite you all to engage in these discussions with the Binding Treaty and to understand how we can try to fill these gaps with this possible framework.
Thanks. And sorry for interrupting. It's just that we have a few questions in the chat. We have very pressing time. So I'm sure that we will have time with the answers of the questions to get deeper into these issues. Thank you very much. Right now, we're going to go to our Q&A session. And as explained earlier, we will have that session now recorded. So if you are watching from home, it has been a true pleasure. We have, with this panel, trying to tidy up the legal frameworks available to understand their practical implementation, their gaps, and to think about pathways to dismantle what Francesca has called the joint criminal enterprise of displacement and destruction. So for all of you at home, don't forget to amplify Palestinian voices, read and share Francesca's report, boycott, don't buy from apartheid and genocide, push your governments to divest and sanction Israel, and to engage with the Binding Treaty process. Thank you very much. And for everyone else here, we continue now with our questions. I'm going to read two clusters of questions that our comrade Shahad Amouri has separated for us. And after that, I'll give the word back to our panelists in the order that they have previously spoken, so they can choose the questions and the issues they feel like they can contribute more. Each of you would have 3 minutes, and now I have to be very strict because we've a bit beyond time right now. Two clusters. First cluster is accountability. The questions we have are, what are the steps to hold violating corporations accountable? What are the tactics beyond business and human rights, like tort law, consumer protection law? Is there any legal criminal liability for EU NGOs failing to cut ties with Israeli charities, companies, universities, for instance, Horizon Europe, partnerships, and so on? So this is the first accountability block. The second is on business and human rights per se. What is the state duty vis-a-vis corporations, and what to do when states are not following their business and human rights obligations to regulate corporations to respect? And finally, in light of the UNGPs, what is the responsibility of food businesses sourcing products from Israel? Should they cut ties entirely with Israel? Are we suggesting that all companies should leave Israel regardless of whether they're national or international, or whether they provide essential or non-essential goods and services? So these are the questions we have from our panel, and I pass on Chiara to have her first 3 minutes. Thank you.
Thank you, Juliana. Many questions. I will try to address a couple of them. Tort law, for instance, could be used leveraging the parent company's duty of care. There are some successful examples, for instance, in the UK, but also in the Netherlands, and there are ongoing cases in Italy as well, as far as I know. But in the UK in particular, parent companies have been held liable for human rights violations committed by their subsidiaries abroad. The Vedanta case is perhaps the most well-known and the landmark case for sure. So there are avenues under tort law as well as the criminal law avenues that my colleagues have highlighted. Consumer protection, I know that there are cases related, for instance, to work conditions in the global supply chains of multinational corporations that have been reprimanded by either national advertising agencies or sued under consumer protection statutes because they were presenting themselves as complying with international labor standards, and yet they were found to have to tolerate basically child labor or forced labor in their supply chains. So why not apply a similar strategy to companies that claim to be socially responsible when they are found to source from illegal settlements, for instance, or to be contributing or linked to serious violations of human rights in occupied Palestine. States' duties, in theory, you could, for sure, states have an obligation under international human rights law to prevent third parties from violating human rights. If you attempt to hold the government accountable, for instance, before the European Court of Human Rights, in a case such as this one, you might face the hurdle of extraterritoriality. You might file a complaint to a UN human rights treaty body. That these bodies, for instance, the Committee on Economic, Social and Cultural Rights, have adopted a wider definition of the extraterritorial human rights obligations of corporations. But of course, their decisions are not binding, and they are more, let's say, a political message against states that fail to adequately regulate their businesses in a way that prevents human rights abuses abroad. For companies, you could also resort to the OECD national contact points under the OECD guidelines for multinational enterprises. Again, this is a non-judicial organ, but if you want to have a further tool to put pressure on companies, this could be an avenue. As my fellow panelists have said, there is no silver bullet, and it can be frustrating, but there are a plethora of avenues that need to be pursued jointly. And I will stop here because I think I've exhausted 3 minutes.
Thank you, Chiara. That was very precise. Irene?
Thank you for all the questions. I will try to answer a few of them. I think I can briefly discuss the point of national company versus multinational and the essential good and service. Of course, here we are focusing on companies that are headquarters in third states, and the obligations that arise from international law is on the third states, so that they can regulate their company. For example, the main issue, of course, has been like the arms and weapon embargo, but also separately from the responsibility of governments. Corporations have also the expectation to respect human rights. So clearly, when we are talking about withdrawing from Israel, we are mostly focused on multinational companies. The point of essential good and service is quite a murky issue that has already been discussed in a lot of details in the context of Russia and Ukraine. Of course, essentiality is quite context specific. There is not a definition of what essential good and essential service are. Of course, normally as referred as like basic goods, basic service like food, water, electricity, healthcare, medicine. So here really the questions for international companies is are they providing essential goods and services in Israel that, for example, that are not being provided by the government, that are not being provided by local company, that if they leave, they will leave the Israeli population, for example, without food, without water, without electricity. And probably like the answer I imagine in this context is no. Here we are referring about companies that are profiting from this enterprise of occupation and the current war and genocide. And I also only want to add one thing that has not been discussed, is that it's true that the UN Guiding Principles are like voluntary standards. They have become quite authoritative now in the 15 years almost since they were endorsed. But at the moment, there are countries that have domestic human rights due diligence legislation in place. A few countries in Europe, France, Germany, Norway, but also countries outside of Europe, Thailand and South Korea, for example, have passed similar laws. So that means that for companies that are headquarters in those countries, the French company, for example, human rights due diligence is mandatory for large companies. So it's not just, and it's not anymore just like a voluntary pursuit by company. Thank you.
Thank you, Irene. Michelle?
Yes, thank you very much. Not so much to add, because already I think Chiara and Irene have really got to the heart of what we need to address in the questions, but only to say that in terms of due diligence, as a state obligation, it's not just an obligation of conduct. There's also a requirement to produce a remedy in situations where it's found that the parties in question have failed in their obligations. So what does that mean? What that means is if you can show as a matter in the courts that the company in question has failed to both conduct its due diligence and endorse the obligations, you may have the state on the hook then to actually do something about it, to pay some form of reparation or to engage in further withdrawal. Now, the problem with this is that at the moment, the way the guiding principles are structured, there hasn't been so much work or discussion about the relationship between due diligence on the part of the state and due diligence on the part of the corporation. But I think there are avenues for legal creativity there where we can try to align both those things together again and get more states on the hook for not failing in their conduct of due diligence to prevent the violations that are ongoing in Palestine. And I'm happy to say more about that afterward if people want me to. That's in a forthcoming publication. Other than that, I think it's important to remember, as both Irene and Chiara have mentioned, that in addition to what Irene and Chiara have mentioned, I think that there is much more now in terms of what we can do politically as a group. So going to our MPs, actually pushing for various states, particularly in the EU, to follow in Macron's statements, to start pushing for self-defense to become part of the narrative rather than it continuing to be, self-determination to be part of the narrative rather than it continuing to be about self-defense. It's not about self-defense, it's about saving lives in Palestine. And I think centering that as much as possible through letters to various MPs, any actions, public actions that can be taken are very much welcome at this time.
Thank you, Michelle. I pass on to Mark. Mark? He's not here? Oh,
Yeah,
good.
sorry. Yes. Sorry. Yeah, I'm just picking up on what Michelle just said, those kinds of actions by citizens to pressure governments, particularly to pressure businesses, ECPs come in very handy because they are exactly that standard that we should expect them and can expect them to be that we can hold them to. And where they fail, we come to this question of liability at the national level. So in response to that question around tactics, I mean, this is a very long conversation, and in fact, I can't even begin to cover it here, but just a few comments, because the question seemed to be asking for advice. So a little bit here of non-legal advice. It really so much depends on the nature of the legal culture in which you're operating. So, for example, in the common law jurisdictions in the US, UK, Canada, and so on, what you see is that cases launched by against corporations for their involvement in international crimes tend to come from victims groups and their supporters in both legal supporters, but also in their supporters in civil society, filed as direct lawsuits, so as tort cases. And sometimes, yes, those can be based on international crimes as torts, as violations of unwritten contracts, so to speak. But it can also involve other aspects, including commercial law or consumer protection law. And those kinds of mechanisms are being used increasingly in the climate action space, where you see cases against corporations based on those more commercial-based provisions. But in the particular Europe or in systems based on those civil law systems, tend to see international crimes allegations against corporations dealt with through criminal law, through the penal provisions. And so groups of individuals, sometimes they're victims, sometimes they're domestic NGOs, will literally file a complaint with prosecutors or with local law enforcement where they have the opportunity to do that. We have that opportunity here in Norway, for example. There's been a complaint filed just today against shipping concerns based on their involvement in shipping goods shipping weapons to Israel. Those kinds of cases have cropped up in other jurisdictions, in places where cases are ongoing. So those are really straight ahead criminal cases. And one of the big differences between the two, of course, is that in one case, it's very much led by groups of victims in the tort law case. And in the other, it's led by prosecutors who might or might not relate to victims or civil society very well. But those are both the ways in which those different legal cultures prefer to deal with cases involving corporations in allegations of criminal international crimes. I'll stop there. There are many resources out there, databases with lists of universal jurisdiction, with lists of cases involving corporations, the Business and Human Rights Resource Center webpage, Trial International, Justice Beyond Borders, and others that you can Google and find.
Thanks a lot, Mark. Andressa, also very, very sharp with time, so we can hear Francesca.
So firstly, tools. We do have some. I don't believe in law developing itself. It's people's powers, and law is always provoked, and we need to push law for things to happen. So firstly, we have the global campaign engaging the Binding Treaty. Every civil society movement, scholars, they can join. We have somebody asked about the countries that are leading the process, not by chance. Palestine, South Africa, Colombia. I mean, you can imagine why. And we do have also some legislation that are being developed in the Global South that goes further beyond due diligence, and that they present, like in Brazil, we already presented the bill. In Colombia, they approved a bill. In Argentina, they presented as well, that provide us tools as well for litigation in those countries. And not by chance as well, Brazil is being sanctioned by Trump because we went further in regulating big techs. So, I mean, we have tools and we have movements, especially coming from civil society and grassroots movements that are pushing for this involvement. So if you want to get involved, just get to know this movement. And I think we have a long way to go, but we cannot give up the fight or lower our standards because it's more than ever urgent for us to hold these companies liable.
Thank you very much, Andressa. Well, finally, Francesca, we would love to hear your reflections, not just to answering the questions, but also in dialogue with what has been discussed here today. We have 5 minutes, so sorry for that, but
No worries. I don't think that I will. Oh, can you hear me? I don't think I will take more than this because the other panelists have been splendid, and my first proposal would be to crystallize all these. We need to have a package, something really useful based on what all of you have produced. I'm glad that my report has triggered this discussion and this moment of opening for the real experts to go ahead and guide toward principled action. So I would just like to add a few elements of broader understanding. First, knowledge is power. The fact, as Mark said, my report is good in offering a synthesis, use this report to understand the system and as a critical lens to approach reality. Knowledge is power, meaning that if states can be, and there are level of complicities that will have to be accountable, but now we need to stop the starvation of Palestinians in Gaza and other places in the occupied Palestinian territory, because it will come if it's not stopped. So while states can make themselves complicit, while government officials can make themselves complicit, we, the people, have a choice, and have a choice in this interconnected system through our wallet, through what we purchase. So there is no one who's powerless in this world. So you need to be careful on what you put in your grocery bag. You need to check what is in where do you have your bank account. There are NGOs these days come writing to me saying, oh my God, we have the NGO's bank is BNP, which is mentioned in my report. How are we going to do? Well, choose another bank. There are banks who have chosen an ethical path. There are ethical banks. We need to help banks develop a genocide-free or an apartheid-free credit score, since Morningstar, for example, refused to deal with the occupied Palestinian territory. So I don't think that, for example, bankers are necessarily bad people. No, there are so many people who don't want to. Simply, they didn't know, they didn't understand to the fullest. And so private investors, so you need to check where you hold your money, making sure that you do not invest in the arms sector, which I'm afraid to recognize that this is the most profitable. But again, you see under your eyes what it does. Investing, giving money to the arms industry leads to this, to the abomination that is in Gaza. But also, it's about time to really provoke a paradigm shift. Yes, there is a need to prompt proper legislation, and maybe it will come, but right now we need to start by holding people accountable. So I've implored the civil society for the 3 years I've been a special rapporteur. Please be coherent with the needs of the Palestinian people. The Palestinian people don't need development assistance. They need freedom. And this is why the civil society now need to reorient their tools and their resources towards supporting this. As Michelle rightly says, from self-defense, we need to shift to self-determination, and we need to hold policymakers accountable. I mean, I appreciate that there are state officials now wanting to recognize the state of Palestine. You need no fanfare. Just do it. Just do it. It's a formality. You don't need to wait for the big ceremony for something that will lead to nothing unless it's supported by accountability. And the accountability starts at our level. Businesses, universities need to cut partnerships with everything that has to deal with Israeli universities or research in Israel. And this is the last point I wanted to make. The question, are we suggesting that it's time to cut ties with Israel? Oh, yes. Oh, yes. No one asked this question when it comes to Russia. No one asked this question when it came to Iraq. No one ultimately asked this question when it came to apartheid South Africa. A state that commits international wrongdoings is a state that needs to face consequences. This is not about one crazy person or three. Netanyahu, Ben-Gvir, and Smotrich. 80% of, I'm sorry to say, but 80% of the Israeli people are still, according to Haaretz and other surveys, demanding the first displacement of the Palestinians. So I'm sorry, it's the state that needs to change. It's the state that needs to be accountable. And from now on, it shouldn't be business as usual anymore. So Israel should, all entities, private and public, should cut ties with Israel. And there should be, this is what because after the sanctions against me, there are many municipalities who are expressing solidarity. So it's not about me. Don't worry, I need nothing other than seeing the end of the genocide. So there should be a BDS focal point in each municipality to advise on ethical procurement, and in order to make the made in Israel unfound, not to be found anymore in our pharmacies, in our supermarkets, until Israel commits and becomes an apartheid-free zone. Thank you all.
Thank you, Francesca. We couldn't end in a better note. A path towards the end of the economy of genocide, towards an economy of justice, requires indeed each and every one of us, and a complete transformation in the way that we regulate corporations and hold states accountable. I would like to thank our panelists, Francesca, especially to our co-organizers, and to everyone on the other side that are fighting within the many different trenches that are contributing to end the genocide. They are fighting for Palestine to be free from the river to the sea. Thank you very much, and see you next time.
Thank you. Bye-bye. It was an honor and a pleasure. Stay strong.
Thank you.
Bye. Thank you.
Bye.